Thank you for volunteering to become a MADD court monitor. You are about to become part of a very important tool in the fight against drunk driving, the Mothers Against Drunk Driving Court Monitor Program. The goals of the court monitoring program are threefold. 1. To compile pertinent statistics on how DWI or DUI cases are handled. 2. To make those involved in the judicial process aware of the public interest and concern about the outcome of trials of drunk driving cases. And 3. To report information to the community so that the system can be improved. Court behavior and decorum. As a new court monitor, you will take your first trip to the courthouse with a veteran observer. The veteran observer will walk you through the process firsthand, answering any questions you might have and helping you handle any situation that might arise. Entering the courtroom for the first time can be an intimidating experience. By law, you have the right to be there, and you will find judges and court personnel more receptive if you follow certain guidelines. Dress professionally, and do not wear or carry anything that features MADD logos.
What shouldn't be worn in the courtroom would be t-shirts, cut-off shorts, anything really, really casual, things that you'd wear around the house. You want to keep your attire professional.
When volunteers come to court, they should respect the office and respect the courtroom. They should take the opportunity to dress conservatively. That is what people are going to be looking at. If they're going to be listened to with credibility, they need to dress credibility.
I think volunteers should, number one, look nice, dress their best. I think that they should wear business attire, professional-looking clothing. And because we're representing MADD, I believe that MADD should be able to walk in that courtroom and be proud of the people that are volunteering.
Ask questions only at the appropriate time. There may be times when you would like to ask the judge a question. Wait until after the case is complete to ask questions. Approach the bailiff, identify yourself, and ask to speak with the judge regarding your questions.
The proper procedure is to wait for a break and then approach the assistant district attorney. You can approach the bailiff, the assistant of the judge perhaps, and if you want to ask a direct question to the judge, you should go through their assistant.
I would become familiar with the courtroom, become familiar with the judge. Maybe introduce yourself at a more informal setting. Go back into the office and introduce yourself, say what you're there for, so the judge will become familiar with your face in the courtroom.
I would recommend that as soon as you arrive, that you let your prosecutor know in that courtroom that you are present. Sometimes we'll already know and sometimes we won't. The prosecutor needs to know so that he can also be aware of the fact that you may have questions instead of totally ignore you. Because quite often during a docket call, he may not have the time to search you out.
From volunteers, I expect interest. I expect lots of questions. I've had a couple people that have been in the courtroom taking notes, and I'm always surprised when they don't ask me any questions, because even on cases I have questions about that I'm even speaking to the judge about. So I expect lots of questions.
Learn the relevant terminology. Words that come up frequently are plea, which is the defendant's response to the charged crime, motion, which are procedural requests made by either attorney and submitted to the court, and voir dire, which means jury selection. You'll find an expanded list of terms in your reference guide.
It's very important to learn courtroom terminology because that is the language of the courtroom. And so in order for all of us as volunteers, as people who are observing in the courtroom, this is the language of the court. In order for us to get the information that we need and get it to our researchers, we have to understand exactly what's going on.
Courtroom terminology is not a lot of information. There's probably only about 10 different terms that people need to learn. And if they just maybe had that on a piece of paper, it would help them to understand what's going on so they really can pay attention to what is being said, the purpose of what is being said versus the words of what are being said.
Well, the general tone of the courtroom is a place of business. This court does business, and sometimes it's pretty heavy business. And so again, we need to keep a low profile and listen. The most important thing you do in court is to listen.
Basics of procedure. Although courts, judges, and terminology may vary slightly, what you are about to view is generally standardized across the country. Upon arriving at the courtroom, you can find the docket posted in a highly visible area outside the courtroom. The docket is the day's schedule, listing case numbers, the names of the defendants, and the charges against the defendant. Find your case and enter the courtroom. Once inside the courtroom, sit as close to the front row as you can. This gives you the best possible access to the proceedings, allowing you to see and hear everything.
It is a courtroom. It should be dignified. It is respectful. It is not jovial. It is not a place to have fun or have a party. Serious matters are being discussed.
I think the volunteers should really take the lead from what they're watching around them, especially the attorneys. It's a formal process and proceeding, and some judges may be a little bit more informal than others, but for the most part respectful of the office and of the circumstances that they're involved in.
I would also recommend that they always keep the appropriate courtroom demeanor while they're in the courtroom, and never, and I will reiterate this, never ever make gasping sounds or anything else that about something that they may not agree with. This is not going to be tolerated and not be looked on favorably.
The basic thing you want to know when you come to court is what the offender's name is. You're not going to find a victim isn't listed on the door. It is the offender.
The procedures of the court. The arraignment is the first step in the prosecution of a DWI. Once the judge enters the courtroom,
Please be seated.
the proceedings generally move quickly. The judge will ask the defendant how he pleads, guilty or not guilty.
Case number 4231B, the State versus Jonathan Smith. The charge is driving under the influence of alcohol. Mr. Smith, how do you plead?
Not guilty, Your Honor.
The defendant makes his plea. The judge will then set a date, and a pre-trial hearing will be scheduled, in which the court will hear and rule on any motions that the defense or the prosecution has filed.
Please be seated.
Both sides will present their evidence to the judge,
Your Honor, the defendant was pulled over for reckless driving.
along with any motions to accept or dismiss certain evidence.
And that is why we would like you to dismiss this case, Your Honor.
The motion to dismiss the case is denied. Counselor, are there any further motions?
No, Your Honor.
A trial date will be set. Next, voir dire, or jury selection, will take place.
The defense and I will ask you several questions. Sometimes we'll just ask for a show of hands.
The trial is the final step in the proceedings. During the trial, your job is to document all aspects of the case. These include prosecution, defense, and judgment.
Mr. Smith, would you and your lawyer please rise? I find the defendant guilty of driving while under the influence of alcohol. The second paragraph has been found true. This means that this is your second offense. I am sentencing you to probation for 2 years. As a condition of your probation, you will serve 30 days in jail and pay a fine of $1,000. Bailiff, please take Mr. Smith into custody. Court adjourned.
It is critical to fill out your evaluation forms as accurately and completely as possible. The information you collect will be used to create a database that will ultimately be used to influence prosecutions and policies regarding drunk driving.
The information that you pull in from being in a courtroom, the data that you're collecting, having an opportunity to analyze that data, you can really take that information to decision makers, lawmakers, elected officials, your community, making a difference in your community by solving problems.
I think MADD has stepped forward in the future and realized that in not only enforcement of our DWI laws and the proper punishment or sentence structure that would make repeat offenders really accountable for their actions, but they've also worked in the direction of education and prevention, which I think is just so forward-thinking of them.
Quite often I've looked at Mothers Against Drunk Driving as being a great ally for us in the courtroom, predominantly to help educate the public because they can see firsthand what travails we put up with in the courtroom, the status of the laws, and also sometimes judiciary. It keeps everybody straight. I think they do a wonderful job in that sense.
It doesn't take high level of experience or understanding of the court system. It merely takes somebody who's willing, somebody who's interested, and people who are willing to come to some training, get some understanding of what goes on. That's really all it takes. And if you're, have a good attitude and you're willing to learn and you want to have a positive impact in what goes on in your community, that's the kind of people we want.
The goals of the court monitoring program: 1. To compile pertinent statistics on how DWI or DUI cases are handled. 2. To make those involved in the judicial process aware of the public interest and concern about the outcome of trials of drunk driving cases, and to report information to the community so that the system can be improved. Thank you for volunteering to be a part of the MADD Court Monitor program. For more information about this or other MADD programs, please contact us at 1-800-GET-MADD, 1-800-438-6233, or visit us on the web at www.madd.org.